So my name is William Morris. I am a patent attorney and a big fan of the show Shark Tank. I love the show. It's great because it's entertaining, but also because patents are a little bit obscure, and Shark Tank does a great job of illustrating how patents can be really, really important for businesses. And it also gives me an opportunity to explain sort of how they work in practice from the day-to-day life of an attorney, which is something people generally don't see at all. So let's see what we've got in this latest episode.
My name is Al Bubba Baker. I played in the NFL for 13 years. That was my job then, but barbecue is my passion.
I wonder what he's patented for barbecue. Is it a new grill? It could be his patented barbecue sauce. You see that a lot, probably by people who don't know what the word patented actually means, but I'm going to bet a sauce, but let's see what it is.
I'm Al Bubba Baker from Avon, Ohio, owner of the D-Bone Baby Back Rib Steaks. I'm seeking $300,000 in exchange for 15% equity in my company. And this is my lovely daughter, Brittany. She's gonna make you sharks, ribs, in a microwave in 2 minutes. Sadly, I married a woman that doesn't like ribs because they're too messy. So I vowed to find a way for my wife to be able to enjoy ribs. But how do you make ribs less messy? You take the bones out. After 20 years, I found the perfect method, and the D-Bone Baby Back Rib Steaks were born. We are the only people that have removed the bones from an actual slab of rib, leaving the meat intact.
That looks so good.
This is absolutely delicious.
Yeah, it's very good.
This is really, really good.
We cook the product with the bone in it.
And so I'm curious. I thought there was some. I guess it's the rib, the boneless rib, right? The boneless rib is the concept. I'm wondering what he's got on this proprietary. If he's managed to get a patent on the rib itself. Like the rib without the bone, or if it's like the process of making it, how easy it would be to make, say, the rib in a different way if it's a patent on the process of making it. I'm wondering if they're going to go into that, because it's kind of an interesting question when you have a product like this where it could be the product itself is innovative, but maybe it's the process of making it that's something that he's been able to protect. Or maybe he hasn't protected anything and he just sees it as very innovative but hasn't gotten any protections on it. We'll see.
Is there anything proprietary about how you're removing the
There we go.
genetically altering cows? They grow up with no
Actually, it's pigs. Yeah, it's hogs.
Okay, so why couldn't I just do the same thing?
Well, I'm not running, guys. It's not that much
Don't run
fish
to the
yet.
top.
He's going to bring a patent out. Awesome.
Right here, Kevin, is the patent for the product. Right here is the patent for the process.
When you have something where it's an innovative product, if you get a patent on the product, that's great, right? Very beneficial, but there's going to be some risk. There's always some risk that people will design around the patent by removing a feature, for example. Same, if you get a patent on the process, then there's some risk that someone is going to put together a patent on the product and figure out, or not necessarily put a patent on it because you've done it, but they'll get a product and they'll figure out a different way of making it. But when you have a patent on both the process of making it and the process, it's stronger together than either one of them is individually. You can't always do it, of course, but when you can, that makes a nice sort of integrated IP strategy. And I love the way he's got these two patents there. It's a great way to answer the question as to what's proprietary, because he actually has 2 layers of protection.
Wow. Can I see the process patent?
Here, take them both.
So nobody else can make boneless ribs?
Let me be more specific. No one else can make a fully cooked rib with either one or more bones removed from it.
Wow.
And how do you get the bones out?
If I tell you that, I gotta kill you.
Yeah, of course, his patent does tell him that, or it should, or it's not valid. I'm sure it does, but it's a cute response. I love how they reacted when they saw those 2 patents, because it is such a good illustration of the valuation of his company and what they would potentially be willing to bid with it. I could see their faces. It goes right up when they saw those two things for this guy.
No, you got a patent. You got a patent for it, Bubba. You can tell. Yeah, tell me.
Robert, honestly, there's the patent, then there's the know-how. And what I say to people who are going to go try and reverse engineer and figure out how to do it, I say, good luck to you, because it took me 20 years.
So when you have a patent, one of the requirements is you need to include a complete enabling disclosure of the best way that you know of to make and use the product or to practice the process, if it's a process. And I understand that he has a lot of know-how, but there's a requirement that your patent has to be something that they can do whatever it is in the best way you know without having to go through undue experimentation. Now, right, it's very fact dependent, but when he starts talking like that, in my mind it raises a question as to whether or not his disclosure is actually sufficiently adequate. Because if it's not, then your patent can be attacked and potentially invalidated. Now, by law, all patents are presumed to be valid once they've been issued, and both of these patents were evaluated by a patent examiner who apparently believed they were sufficient. But what he's saying here, when I hear that, it is a little bit worrisome, and if I were, say, buying the patents, for example, I would want to dig into that a little bit more to see if that should influence the value that I place on those IP assets.
Now, what are your sales and how many locations are you in?
Okay, our sales are $154,000.
Over what period?
Over a year's period. We're selling in about 48 stores.
Okay, guys, I actually am an investor in a restaurant chain with 450 locations that sells a ton of protein. This is their second largest selling item, ribs. Here's the big problem with your deal right now. You're asking for $2 million valuation on this thing. You're not making any money.
I wonder if he's going to go with a licensing deal, because if he's already got a really good distribution network set up in the form of these 450 restaurants, it might be worth more to him to simply get the tech than it would be to buy his restaurant, which it sounds like he doesn't think is making all that much money. Again, with the patents, that becomes a very easy thing because he can put it in, and then none of his competitors for those 450 restaurants can say that they have anything similar to it, because I'm assuming he would be the exclusive licensee, is probably what I would request.
The only value here is in the patent. This reminds me of a story that's so relevant to you.
I love
The first season of Shark Tank, a guy stood right where you are, he had a folding neck guitar. He wanted to build out a guitar company. The only thing of value was the patent on the folding neck technology. You know where we are today?
Where are you at?
They are licensing that technology on fender bender guitars all around the world.
A licensing deal. It makes perfect sense for
I
that.
want to take you to one guy. So my offer is very simple. I'll give you the $300,000. It's contingent on getting one of the large meat processors in America to license the patent. But I want 49%. That's the deal.
So is this like a 49% broker fee for introducing him to someone, or is this 49% of the restaurant?
All 5 sharks are still in. Kevin has made an offer of $300,000 contingent on a licensing deal with a large meat processor. But he wants 49% of Al's company.
Oh, just the company, not the... Alright.
First time Kevin actually has a decent idea when it comes to something like
It's
this.
the first time we've heard his stupid idea making any sense.
That idea is so brilliant, I'll do the exact same deal, but I'll only take 30%.
Damn, Kevin.
I'll give her.
I think you're paying a very expensive price for somebody to make a phone call for you that you could do on your own. I'm out.
I would have pitched you that I should bring you to some of the big box stores, some of the club channels like BJ's, Costco, but I happen to think sending you over something to take a lot better than it's all now.
For me, the business would have to be a little bit bigger. That's why you're limited kind of to the licensing play. So for those reasons, I'm out.
Al, you got 2 offers.
Yeah.
Both licensing deals. Al, is this the path that you want to go down?
He should take the licensing deal. It's absolutely the path he wants to go down, because what he's got is really valuable IP. And if he makes a restaurant The restaurant, what it's going to have is really valuable IP. That's what it's going to have, is this really nice thing. And they're already bringing that to many existing restaurants. They've got great connections. It looks like a very natural licensing play to me. I'd go with Damon.
Discount license guy.
Day one, you're not taking a check, and he wants to take 50% of your company.
49. I'm worth every cent of that 49%. What are you gonna do?
Kevin, I love the fact that you have made us an offer. I think I'm gonna take Damon.
It's the better man, Michael.
Right in front of me.
Thanks a lot.
Right deal, Al.
Thank you. Thanks a lot. Thank you.
Congrats, guys.
That guy's walking out with a deal because he had a patent. He had 2 patents. They were complementary to each other, and it was a great product. Nice. What a show. What a set of patents. I want some ribs. Alright, so I am here at Hardee's, the home of Charbroiled Thick Burger. Hardee's purchased 1 million pounds of Bubba's boneless barbecue ribs. And so I came here to Hardee's because they look delicious. And I'm here with Deja. So, Deja, can you tell us a little bit about these ribs that I'm about to be eating?
The ribs are good. They're delicious.
Patented. You sell these at any restaurant?
No,
only at Hardee's. I know that because I'm actually from Cincinnati. So I had to drive 40 minutes to get here to eat these patented ribs because I've never eaten a patented sandwich before. And I am a patent attorney. You know that? Maybe you did. But I'm a patent attorney. And now I'm going to be a patent attorney. I will literally have patents in my blood because I'm going to eat these sandwiches, and then the intellectual property will become a part of me in my body. And so there you go. That's the plan. So you can see the ribs in there. I just licked my fingers. There is some serious barbecue sauce on this. Can I eat the sandwich now, please? What if I took a client here? Like, hey. Why are you taking me to Hardee's? And this is a demonstration of the value of patents, because you know the guy who invented this is now unbelievably successful because he had patents on his sandwich. This is an object lesson in the value of IP. Therefore, you should also get a patent. I'm not your attorney, by the way. I'm not saying that anyone should take that as legal advice, because I'm not giving legal advice. I'm eating a sandwich. It's good. They definitely spurred some sandwich innovation here. One thing I'm thinking about with this is when you have a patent, when you sell a patented product, you normally what you do is you mark it, which means you have like the word patent or the abbreviation PAT, and then you have the number of your patent. And the reason you do this is if I sue someone for infringing my patent, if I have marked it, then I can get damages from before when I sued them. The benefit of it is you get more damages. The downside, I guess, is you can't really mark these ribs. And normally you'd mark the packaging in that kind of a case. This packaging doesn't really look like it lends itself particularly well to marking. I bet in their sort of, whatever they bought them in their crates or their cases, in the back of the Hardee's, probably marked. I am not going to go back there and ask them if I can look, but when we go to Meijer's later, because they also sell these boneless ribs, I'm definitely going to take a look at it because I'm curious if he's marked his patented ribs. If I would guess he would, but again, a little bit tricky to mark a rib itself. So here we are outside of Meijer, and we are going to check out and purchase some patented ribs. So here they are, the Bubba's Q boneless baby back ribs as seen on Shark Tank, fully cooked, bones removed. Now the big question, are they marked? Where's the patent marking? I don't know. I would have expected to see it say somewhere patented. Alright, so I am back from my Ribstravaganza field trip, having had some hands-on experience with Bubba's barbecue ribs via Hardee's, of course, because I didn't drive all the way out to BBQ. But I think actually that my experience with Hardee's is very useful sort of as an educational coda because it demonstrates a few things. The first thing it demonstrates is the power of licensing this and making it so that other people can use it. Because Bubba, great barbecue guy, I'm sure he is, he's got his own shop, but I didn't drive all the way out to BBQ. I went to Hardee's, and I'm pretty sure that Bubba himself did not debone 1 million pounds of ribs. And so the way that this was monetized, the way that this was made into a commercial success, I think demonstrates the value of being able to disclose your product and being able to teach other people how to do it in a way that's reproducible, not just for a patent, but also because if you want to scale something up, you're going to need to be able to do that with other people. You're not just going to do that yourself. We also saw that in this case, the patent was at most half the picture, right? So they licensed it out. Patents are great for licensing for sure. But what a patent does, it gives you an exclusive right to make, use, sell, offer for sale some kind of a product or perform a method. But if you've got a product nobody wants to buy, that right to exclude other people really isn't worth anything. When you, however, have a product that people do want to buy, or more accurately, they want to sell to others, like Hardee's wants to sell their boneless rib sandwiches, having a patent on that, it's like an afterburner. So you need to have fuel of a good product. The patent makes that fuel. You get the most out of it that you possibly can. And then the last thing I got out of this trip was actually a little bit of a surprise to me. So I was honestly expecting the packaging for this boneless rib to say patented, like P-A-T, and then have the number of his patents, but it didn't. There was no indication whatsoever that it was patented, which was surprising because that was a big part of his business pitch, but also because if you don't have that patent notification, the patent marking, it can reduce the amount of damages you can get if you ever have to sue someone for infringement. So anyway, good, delicious lesson, a lot of well-digested facts and also ribs. But that's it. So if you liked it, please remember, like, share, and subscribe. And, I'm curious if there is a Shark Tank episode that you think is particularly patent-friendly and you want to have my sort of expert commentary on it, put a comment on that down in the comments, and I will try and get to it, and we'll see. Maybe I'll have some insights, or maybe I will just rant for the entire episode, which is also possible. But anyway, let me know what you think, and I will talk to you later. Bye-bye.